Karen Reed stood on the steps of the courthouse in Dedham, Massachusetts, and proclaimed her innocence, telling the world she did not murder her boyfriend, Boston police officer John O'Keefe. And as Karen proclaimed her innocence, she also pointed the finger at the people she believed were responsible for the murder, people who she claimed were framing her for murder. Then, a local blogger named Turtle Boy picked up the story, believing Karen was framed by dirty cops. Then Turtle Boy's followers started showing up at the courthouse, making allegations of a conspiracy and a cover-up. Things got personal. It divided the community. Then, finally, the trial happened. 9 weeks of testimony and evidence meant to clear things up and show the truth to the jury. But in the end, the jury was as divided as the community, and they deadlocked. So what now? How will either side get the whole truth in front of the next jury? Tonight, we take a look at the evidence no one presented, the evidence the jury didn't hear or see, and ask the question, will the prosecution or defense show it to the next jury? We'll do this as we continue our investigation into the tragic death of Officer John O'Keefe. I'm Vinnie Politan. Thank you for joining us tonight here on Closing Arguments, still in the aftermath of the jury being deadlocked in that long trial of Karen Reed. Basically, at the end of the day, nothing was proven. That's your real takeaway. In our system of justice, for something to be proven, it needs to be proven beyond a reasonable doubt, and it wasn't. And it wasn't, because the jury came back and said, no, we don't all 12 agree. And that's the only way that you can prove your case in our system. A prosecutor has to bring in the evidence, convince all 12 must agree it didn't happen. So we're back to square one, where nothing was proven, she's presumed innocent, and it's up to prosecutors to try again. The really sad part of all of this is that the family of John O'Keefe, his mom, his dad, his brother, they deserve the truth. Whatever the truth is, they deserve the truth in this case. And the evidence presented did not get the jury there. Individual jurors may have felt that way, but collectively they didn't. They did not, one way or the other. So for the family to get the truth, I think in this case, you're going to need additional facts. You're going to need additional facts in this next trial. Absolutely. Because I believe they didn't hear everything, this jury. Because the way the case was tried was that there were really two cases being tried at once. Karen Reed for murder, and the lead investigator, the folks in the house, and Canton police for an alleged cover-up and conspiracy. So once that conspiracy ends up in the mix, it really changes fundamentally the way this evidence is coming in and what the jury is perceiving and what they have to figure out. So, unfortunately, someone needs to come forward with more information to get this jury to the truth. And I'm talking to both sides here. I'm talking to both sides. And who will reveal the truth here? Will the prosecutor bring in more evidence to show this jury that this whole conspiracy is impossible? Not based upon what someone said, but some real, like, basically irrefutable evidence. And is there a video somewhere that we didn't see? Likely not. Or if there was a video, someone got rid of it, right? So I don't think a video is going to suddenly appear in this case. But how about records? How about data about the location of everyone? Everyone, because remember, it's an alleged conspiracy that people conspired to do what they did to John O'Keefe. So conspiracy involves a lot of different people. And we know there were people in and out of that house. So let's start here with John O'Keefe, his cell phone data. You take a look at it, you had witnesses for both sides talking about John O'Keefe's GPS location information, his Apple Health data, his movements. Like, at the end of the day, the jury got an idea about what the data said about where John O'Keefe's phone was and what it was doing. Okay? It ended up with a little bit of a battle of the experts. But there was a good foundation built around John O'Keefe's cell phone. Great. He's the victim in the case. Karen Reed's the defendant. Phone calls from Karen's cell phone tracked her movements on the night of January 29th. They used this also to find surveillance video of her car. And we know when she got back to the house, when she hooked back up with the Wi-Fi. Like, they're using evidence to track her. They're using this evidence to track her whereabouts. So we're able to follow and figure out where she is and when she's there. Data from her car backing up, all this stuff was used to tell this jury, not through some witness who said, yeah, I saw her at this time, but data that says she is somewhere at some time. Well, what about the rest of the people in the house? There's a bunch of them. They all testified. But at the end of the day, their testimony wasn't enough. Either the cross-examination or the direct wasn't enough to convince the jury one way or the other, collectively. So isn't there some way that someone could help us track where all these people were and what they were doing in the hours in question? Well, let's find out. Joining me tonight, he's the best, criminal defense investigator, Charles Middlestat with us. Also joining us, the former head of the homicide unit in the Norfolk District Attorney's Office, Attorney Rick Grundy, and finally, criminal defense attorney, college instructor, author, Peter Ellikin. Great to have all three of you tonight, handpicked by me to be in this segment tonight. Charles, you know something about phone data. You know a lot. You're able to put people together, you know. Don't need to get into all that, but let me ask you, Charles, if you've got all these people in the house, most people have phones, as we sit here tonight getting ready for a new trial, is it possible, like logistically, I'm not going to get into the legal wrangling yet, but logistically, to find records from cell phone towers or somewhere else where you can help track the location of the other people who were in the house that night?
There certainly is, Vinny, and again, I didn't follow this case gavel to gavel, so I don't know the full scope of the testimony or the evidence in the case. But certainly, what was available to both sides was simply with a subpoena was the ability to subpoena every single individual's phone records, the call detail records, and also the geolocation data associated with those phones. And that's done simply with a subpoena to a cell phone provider. It's very easy to determine the carrier for each individual subscriber that we're dealing with. And it looks like we're dealing with about 10 different individuals. And certainly the defense would have had access to that. They would have had the ability through their discovery powers to leverage that data. Now, as to whether those records would exist anymore or not, really it depends on the carrier. Each carrier has a different policy with regard to preservation. And so some of those records may still exist, some of them may not. But what you would be able to do, in addition to the geolocation data, and frankly, more important, I think, at this stage than the geolocation data associated with those individuals within the household is the call detail records. Because if something happened inside of that house, I suspect that there would have been a flurry of activity on those phones. You would see text messages, you wouldn't see the content because the content's not going to be within those call detail records. The content would reside on those phones, and you would actually need to have physical custody of those phones in order to image them.
Well, some of those phones have been destroyed, so they wouldn't necessarily be available. So let me ask you this. Let me follow up on something else. Is there any other way to track locations of cell phones in an area? Can you get data straight from cell phone tower records? Is there anything like that exist?
Well,
or is that the geo-fence stuff?
That's the geolocation. So again, when you're subpoenaing the call detail records, within that is the geolocation data. And so you have, it's broken into two categories. You have the cell tower data that you're referring to, Vinnie. And then in addition to that, you have historical GPS data, and there's a third segment, which is the engineering data, which often I just subpoenaed some AT&T records. And so I not only got what's called NELOS data, that's AT&T's proprietary historical GPS data, which is far, far more precise than cell tower data. Cell tower data, you get into propagation studies in terms of range and so forth. GPS can be accurate within 3 meters, not always, but it's far, far more accurate. It's not depending upon a tower. And then you also have this engineering data, which is also generally GPS based, which is also incredibly accurate. And so between those things, it is very possible to very precisely place somebody there. Now, with all those phones, whether they, again, a lot of these phones don't exist, but at the time, certainly the prosecution, had they gone in there, had they actually done proper interviews, had they actually taken some of these phones into custody, or at least sought permission to look at them or questioned these individuals about whether anybody had taken pictures, shot some video. You know, we often do witness mining based upon getting a picture. We talk to a witness, hey, did you take any pictures that night? Yeah, I think I did. And then we get a photograph, and in the background, we're able to identify 3 or 4 of the people in the background. So there's more witnesses, and now we identified. Now we're broadening the scope of the witness pool.
Well, let me ask you this. Let me ask you this, though. Bottom line, with just tracking the location of everyone, whether they're moving in and out of the house, whether they're in the front yard, when they leave, can you do it without the phones? If the phones are gone, you can do it without the phones.
Well, you can place them in the general location. If you're relying on cell tower data, then you're going to be relegated to placing them in the general location of that residence.
Okay, but that may be enough in some of these instances. Rick Grundy, we sat through this whole trial. It's very unclear about any movements of any of these people. It's unclear exactly what time they show up, when they leave. Is it incumbent upon the prosecution at this point to attempt to bring that evidence in, because from his perspective, he wants to erase that reasonable doubt that was being raised and obviously was raised during the course of this first trial? Do you see this as an option in the second trial? What would stop him? Why wouldn't a prosecutor want to uncover as much truth as possible, which could, from his perspective, erase reasonable doubt of this so-called conspiracy?
So I agree with the overall premise. More information is always better from the prosecution side because, you know, I always tell young prosecutors the best thing you got going for you is that your job is to present the truth. Find the truth and present it. So more information is always better. But beyond that, I think one thing that the prosecution erred in doing in the case was chasing down little landmines that were placed by the defense that we found out they couldn't follow up on what they said the jury was going to get to. Too much of the trial was spent on that. So I think, you know, with respect to those individuals in the house, they all testified they were in the house. I'll defer to Charles, but my understanding of what's available at this point in time is not going to, if you could get Higgins and Albert and the young kid in the basement, you know, alone, you know, that would be great for the defense. But they're all in the house. You're not likely to get anything more precise that's going to swing the pendulum one way or the other. But let me tell you this:
if they still have their phones, and they have Apple phones and they have Apple Health, and they're not walking up and down the stairs, and you can show their movements, you can show when they left. Why wouldn't the prosecution want that? Why wouldn't the prosecution get it and try to present it? He knows that he didn't succeed first time around. I mean, something's got to change. We know the public reaction to the evidence in this case. Something's got to change if the prosecution believes they're in the right here and they want to win.
I like the idea that Charles put forth with respect to, there's going to be scampering. I mean, if there's nobody leaving the house by the side door or the storm door or whatever it was that supposedly dragged this body out, obviously that's great for you. But again, you're disproving, which is important, but I'd want them to focus on proving. And to be honest with you, I don't know that information wasn't available as much as it wasn't presented in the strongest manner and in a most effective manner. If John O'Keefe never gets, that's where I would want to focus. If John O'Keefe never gets into the house, game over on the defense theory. That's it. It's done. He never approached that threshold. It just didn't happen.
Let me ask you, Peter Ellikin, for the defense, legally trying to get some more of this information. This defense is different. They are not saying that they can't prove it. They're saying, they run the courthouse steps saying she's innocent. She's absolutely innocent, and someone else did it, and we know who did it. Like, at this point, getting ready for a second trial, you just sitting back and just letting it roll, or are you going to be aggressive in perhaps trying to reinvestigate the case and try to get more information because you believe that your client is factually innocent? They've been using those words, factually innocent. So do you think they need to be a little more proactive so they can show this jury why you can't believe this prosecution theory?
Yeah, that's exactly what they should be doing. But here I'm going to play a little bit of a Mr. Negativity here about
Sure.
A little pessimistic about whether that information is available anymore. As we know, the phones of the people in the house, virtually every single one of them either deleted their phone or took their phone and threw out and destroyed the SIM card. So saying we'd like to go back, boy, that information would sure be valuable for us. That would that just the parade may have gone by. That may not exist anymore. I know Charles had mentioned something about it'd be great to see even the phone communications or when they.
Okay, let me cut you off because I think there's one moment here that is significant. Okay, this was a significant part of the case. The plow driver who testified. Let's take a listen so I can remind everyone what we're talking about here.
What time was it, to your best estimate, in terms of when you would have approached Fairview and Cedar Crest again?
3:15 to 3:30. At that point, I saw a Ford Edge on the side of the road.
Where was it parked on the side of the road?
In front of the Albert's house.
Where in front of the Albert's house?
By the flagpole.
All right, Charles, I'm going to go back to you. If it's 3:15, everybody supposedly left the party, but now someone's pulling up in a Ford Edge or parking a Ford Edge near where the body was ultimately found. How would you go about trying to figure out if someone is milling around at 3:15 at this point? Not the initial investigation, but right now.
Again, the cell phone records. The cell phone records are completely different than the phone extractions. Phone extractions are going to be dependent upon having access to the phones. If the phones are gone, they're gone. The records are the records. There's no way to interfere with those. You can't erase the records. There's no ability on a subscriber's part to manipulate the records in any way whatsoever. So if someone was engaged in texting between parties, if there was some sort of scurrying going on because there was an injury in the house or an incident occurred, again, it works both ways. So the absence thereof, it works in the prosecution's favor. The presence of activity amongst those 10 folks in the home would indicate, first of all, that would have been great for cross-examination. If you, as the defense, to be able to say, hey, I see you two people were texting, or you were texting this person, or you were making these phone calls. Here's a 2-minute phone call with so-and-so. What was that conversation about? What were you texting about? I mean, these are all the things. Well, in this case,
it turned out to be a butt dial, they said. They claim mutual butt dials, a double mutual butt dial at 2:22.
That's a new one. Yeah. But the main thing about the records is it has the ability to very positively timestamp certain events. And so with the geolocation data, like the plow driver there, you could timestamp his presence in that area.
How about the Ford Edge? If you know which Ford Edge it is, are there records related to the car company, would they have anything? Is there any way to specifically locate a car, like a Ford Edge?
There's connected car technology. I don't know if Ford Edge has that sort of sophisticated connected car technology where you could actually download from the EDR, the event data recorder. It might have some data in it. But again, I don't know how much law enforcement did with regard to nearby ring cameras, nearby surveillance cameras of other
couldn't find them. Nobody in the neighborhood had a Ring camera that was working. Apparently, that's another problem in the case. All right, everyone, stay where you are. This is why I invited them on. They know what they're talking about. When we come back, we're going to talk more about Trooper Michael Proctor Plus coming up next hour. It's the next huge trial on Court TV. A-list celebrity and actor Alec Baldwin will be inside a New Mexico courtroom facing homicide charges. Tonight, we take a closer look at what happened on the set.
A-list actor Alec Baldwin is cast in the real-life role he never wanted.
I turn cup because the gun goes off.
Criminal defendant.
His lack of gun safety is something that he's going to have to answer for.
We heard that this was a toxic set.
One more.
It's not his fault. He did nothing wrong.
Is there an actor's exemption from liability when they're handling a deadly firearm?
The Alec Baldwin manslaughter trial. Live coverage begins Monday morning only on Court TV.
Fact of the matter is, you delivered that car to Canton PD, to the Sallyport garage, before a single piece of taillight material was ever found in this case. Trooper Proctor, is that correct?
Correct. It arrives at 5:31.
This is a big deal for the defense. This is sort of the part of the foundation of their conspiracy and frame job is that Trooper Michael Proctor is the one who takes pieces of the taillight off of Karen Reed's car and then plants them at the scene. And the timing of this is significant, right? Because no one finds a piece of the taillight until Karen's car, after her car's been seized and brought back to the Sallyport at the Canton PD. So here's more of Trooper Michael Proctor's testimony. This is about what time it was seized, because every minute counts here. Take a listen.
You were responsible for seizing Miss Reed's car, correct?
Yes.
And you originally claimed that that seizure took place at 5:30 p.m. Is that right?
Correct.
You signed numerous affidavits under oath, claiming that you did not seize Miss Reed's vehicle until 5:30 p.m. on January 29, 2022, right?
Correct.
At the time that you seized Miss Reed's vehicle, you were unaware that there was Alarm.com surveillance footage of the area from which the car was seized, correct?
Correct.
The fact of the matter is, that was false. The car was not seized at 5:30, was it?
4:16 p.m.
Right. An hour and change, an hour and 18 minutes, hour and 20 minutes earlier. Is that right?
Yes.
Did you ever seek to change or amend the error, the false statement about the time?
So,
or seized in any of those documents that you filed under oath?
When I incorrectly transcribed the times, it was on the first affidavit I had written. And then as I continued to write other search warrants, I used that as a template. So I never caught it on the first one, and that's the reason those times are off on the other affidavits I had wrote.
So the first one was false, and then every single one after that was false too.
It was just an incorrect transcription of time.
An incorrect transcription of the time.
Yes.
You call that, I don't know, a Scrivener's error?
Objection.
Ask it differently.
Sure. Was it a typo?
Yes.
It was a typo. So you got the 4 wrong, you got the 1 wrong, and you got the 6 wrong. And those turned into 5 and 3 and 0, right?
They were typos, sir.
And every minute counts here, right? Every minute counts because it's got to get from Karen Reed's parents' house to the Canton Police Department. It's about 40 minutes. Could be a little less, could be a little more, depending upon how quickly you're going. So there's a window of time when the car gets to the Sallyport that he has to, according to the defense, take the pieces of taillight, then bring it back to the scene of the crime and plant it while the CERT team, the emergency response team, is recovering this stuff. So the window is really small here. So let's bring back in our guests, Charles Middlestat, Rick Grundy, Peter Ellikin. So the piece of taillight's got to go from the Sallyport to the crime scene to be planted, right? And there's video of Proctor here at the Sallyport, and he's behind the car by the taillight. You don't know what he's doing. Charles, is the equation any different when it comes to figuring out if Proctor went back to the crime scene? If it's a police officer versus a regular civilian trying to track them, are there more records for the way police vehicles move? You know, I'm trying to figure out why we didn't hear exactly where he went after he left the Sallyport.
Yeah, I think it's incredibly interesting and obviously highly, highly significant. I don't know what kind of vehicle he traveled in. Whether he was in a. Did he drive that vehicle?
No, that was towed.
That was towed, right. So is he in a marked car? Does it have a dash cam? Does he have a body camera? Is he wearing a body camera? Is he with anybody wearing a body camera? Look, there's going to be, during that route of travel, there should be an enormous number of different cameras along the way, and particularly early on when he seizes that vehicle, those are the ones that I'd have the most interest in to see if there's any way to.
How about his cell phone? Would his cell phone tell us?
Absolutely, his cell phone too, but I'm trying more specifically to determine whether when that vehicle was initially towed, whether that taillight was intact initially.
Oh, that's a big issue. There's pictures, and every picture is just not clear enough to figure out. Depending, you know, it's like one of those tests. You look at it, you see what you want to see, and that's another divide in all this. Let me ask you, Rick Grundy, why wouldn't the prosecution just present some definitive evidence about where Trooper Proctor went after he left that Sallyport? Something beyond his own testimony.
So my speculation on that would be that they don't have it, didn't develop it. Just to fill in some of the things that were just said, unlikely he's going to have a body cam, possibly a dash cam, but unlikely he's going to be in a unmarked car working out of the district attorney's office. But he's got, you know, he's got his state police radio. He's got obviously at least one, if not two, cell phones. So my thought is that, you know, normally you have a state police officer and you feel that they've done a thorough and appropriate job, particularly those that are assigned to the district attorney's office, and that they have the credibility to present their actions through their own professional testimony. Here's an area where I agree with you. They may well want to, they certainly do want to, in light of the actions that were taken recently, go back and you got to find whether it's other people, whether it's the chime cameras along the way, whatever it is that corroborates what Proctor says needs to be summoned for this second trial, because he's now in the position that I thought he should have been when he testified the first time. That is, disgraced and removed.
And removed from his position. So, Peter Ellikin, does the defense want to dig deeper to specifically prove where Proctor was? Not like, there were two people there, nobody knows who they were, there's a window of time here, he had time, it's only 5 minutes from the Sallyport to the crime scene, he could have gone there, he could have easily planted all this evidence. Do you, if you're Alan Jackson, David Yannetti, do you want to dig deeper? Do you want to hire Charles Middlestat to find out exactly where Trooper Proctor was for those 15, 20 minutes?
Absolutely. It would be so great to have absolute certainty and as opposed to what we were left with, just reasonable doubt that, yeah, well, he technically had the time to get there and nobody really saw and knew where he was going. That would be ideal to do it. I don't know if all that exists anymore. A lot of those sort of documentation and the cameras and all that, they don't save it over that long a period of time. Hopefully, it would have been better if that was done sort of in the past. If anything exists there, that would be so great to really finally have a real smoking gun, an aha moment, as opposed to this, well, geez, they just didn't prove it beyond reasonable doubt, and he could have been there. So the defense did a good job of raising those questions. Yeah, it's a possibility.
Yeah. But they're telling us she's innocent, so they can answer them. I mean, if the evidence exists, I mean, to me, this should be the goal of both sides, if they truly believe in their case, is to show this next jury where Trooper Proctor was for those 15, 20 minutes. Everyone's staying where they are. When we come back, we're going to talk about the house that was never searched. Could there be a search of the house now? Could you find any forensic evidence? My goodness, in some of the cold cases we cover, they go to houses after 3 different people have lived in there. Would any evidence be left behind?
Did an investigator or any forensics team ever come into your house, ever, to photograph your entire home?
No, I wish they had.
Did an investigator, yeah, me too.
What a moment. Brian Albert, the owner of the home that was never searched. I mean, this, according to the defense, is the scene of the crime. Prosecutors obviously say nothing had anything to do with anything happening in the house. It all happened on the yard because it was basically a hit and run for the most part. So let's take a listen to more of the cross-examination of Brian Albert talking about what they didn't do and the status of the house.
Did an investigator or forensics team ever come into your house to search for physical evidence?
No.
Did an investigator or a forensics team ever come into your house to search for trace evidence?
No.
Did an investigator or forensics team ever come into your house to take carpet samples, flooring samples from the basement, for instance?
No.
And to this day, you're aware that that's never happened?
Yes.
By the way, the 34 Fairview house had been in your family at that time in 2022 for 2 generations?
My parents built the house in the late 70s, 79 maybe.
So if your parents are 1 generation, you and your family are another generation, 2 generations.
Right.
Nearly, maybe actually a little more than 50 years, half a century.
That what?
That it was the Albert home.
Yes.
The fact is, you listed that house for sale for the first time ever in November of 2022, correct?
That's the time we listed it, yes.
Just months after John O'Keefe was found on your lawn.
Objection.
Stand.
All right, the defense theory is clear that they believe some murder took place, a beating death of John O'Keefe down in the basement. The basement, according to the homeowners, had a water problem and they redid it before they sold it, the basement part. But Charles Middlestadt, this house has never been forensically searched. Would it be worthwhile for the defense to hire some expert, go through it and see if you can find anything?
Well, I'm going to get on my soapbox for 20 seconds here. So, what we're talking about here is a lot of burden shifting. I mean, what the defense has done and what it should never have to do is, it should be able to dispute the accuracy and the reliability of the state's evidence. And that's what it's done. And it resulted in a hung jury. Now, what we're talking about and what we've been talking about mostly is what can the defense do to prove its case, to prove its theory. And, that is...
To win. She wants to go free. She wants to go free.
I understand, but it is burden shifting, and the state has a problem. They have a disgraced cop who's been terminated. He's been impeached, and they're the ones that are have to explain this. But the fact of the matter is, it's a botched investigation. There are some very odd circumstances surrounding the connectivity between all of the witnesses in this case and the occupants of that house and the lead investigator. And so it was incumbent upon the prosecution to foresee all of that and try to overcome all of that with some good evidence and some good explanations for all of those things. And they were either unable to do so or didn't think it was going to be important.
I think this gets us to another place, Peter Ellikin, and I'll just throw it to you. Do you think the defense is going to be happy with another hung jury? Does she want another 3 months? Does Alan Jackson want to move to Boston for another 3 months for another hung jury and then try the case again?
The last thing they want to do is go back to square one, go to the starting block and do an entire do-over of the thing all over again. Absolutely, they don't have, they would not want to do that.
Do you think they'll want to search the house?
Yes, but again, like I said, I'm a little pessimistic about that too. One of the things that really annoyed me in this case is when people would accuse the defense saying, oh, you guys are talking about he got beaten up in the house. Where's your evidence? Where's your proof? You got nothing. Of course we don't have any. Of course the defense
There was no investigation.
Yeah, there was no investigation, and now that they've ripped up the floors and redid everything and all that, I don't know that anything is left there to get. And this is why I say that it's such an unfair thing that perhaps if you have forensic people in there, could they find a spot of blood somewhere?
I mean, in cold cases, sometimes they go in and they find something. I mean, if you found John O'Keefe's blood in that house, it's game over. Your client walks. Your client walks.
And if you don't, then it's counted against you. Now you've assumed a burden that you shouldn't have to, and if you can't make your case, then it actually works against you. And so I don't think they should lift their finger like that. I think they should work with what they have.
Okay. Let me show you something else here, Rick. Here's Nicole Albert talking about. Now, remember those wounds on the arm. One side saying it's the tail light that made all those cuts on John O'Keefe's arm. The defense very clear that it was Chloe the dog inside the home. Here's what we learned about Chloe the dog during the trial.
You testified that your German Shepherd, Chloe, was also at the house when you arrived home on January 29th, correct?
Yes.
She's a large German Shepherd.
Yep, about 70 pounds.
She's not great with strangers.
I wouldn't say that.
You wouldn't say that it's kind of a poorly worded question. Would you say that she's good with strangers?
I'd say she's fine with strangers.
Fine with strangers. Ms. Albert, Chloe has injured other humans, hasn't she?
Objection.
I'm going to allow that.
In one incident in May of 22, when she got out and was fighting with another dog, the woman whose dog it was tried to break up the two dogs, and while she was trying to break up the two dogs, she got injured.
Ms. Albert, you don't have Chloe anymore, do you?
Nope.
In May of 2022, 4 months after Mr. O'Keefe's death, you got rid of your family dog of 6 years.
Objection.
So is that true? Is that when you got rid of your dog?
I did not get rid of my dog. I rehomed my dog.
Your dog is no longer in the Canton area, correct?
No, but I know where she is. She's in Vermont.
Rick Grundy, should the prosecution go find Chloe? Maybe get an expert to take a look at Chloe's teeth and then take a look at John O'Keefe's arms and show this jury that this wasn't a dog bite?
So I think the next thing that she said was that, and I've provided the information as to where Chloe is and offered Chloe up for whatever testing. And I know that there was a testing of the wound for dog DNA. So again, I think they are, you want to be careful as a prosecution not to spend all of your time and put your focus on chasing down the defense's theory. We spoke the first night, Vinnie, after openings and agreed upon that it was a very strong and effective defense opening statement, but that they may have pushed the envelope a little too far because they definitively said, we're going to prove to you that Karen Reed was set up. So Charles is
They actually said the word framed. David said framed. David Yannetti said she was framed.
Correct. So there was burden shifting, but it was voluntarily. So where the range were pulled in on closing the loop on some of these things, I think that the defense thoroughly went through Proctor's phone and tried to place him at places and was unable to, or certainly unable to in a method that would fill in their theory of the case. And, you know, I can't do it. The prosecution can't do it, but I'm relying on the media people. The first thing, it's best to have a roadmap to know where you're going. And the first thing I want to know is those people who were on the not guilty side, was it not guilty because we find that the defense didn't come through with this whole frame-up thing, but the Commonwealth didn't prove their case? So I wanted, when I'm building this second case, that's the information that would be most helpful for me. If it comes back and they say, hey, look, we found this, you know, these wounds, very troubling. Yeah. I got to do more there. Or tracking people. I got to do more there. But if it's because
we have to leave it there, Rick.
Didn't,
I always do this to Rick. It's always Rick. Rick gets it every time.